Well, hello everyone. Very excited to have my friend Ron Rohde join me. He's the legal expert. Everything that I need to do that has anything to do with the law, I reach out to Ron. He's also a really good industrial guy and YouTuber too. So there's more than just law, but we're going to be talking law today, and specifically the announcement yesterday that a federal jury, found the National Association of Realtors and Keller Williams, found them that they colluded to keep commissions artificially high. And in that verdict, they were awarded $1.8 billion in damages. And the judge has some leeway that he could even have that go over $5 million if he so chooses. So, Ron, first of all, that's a mouthful. I don't even know why I had that memorized, but I'm very curious about this myself. So, first, before we jump into it further, good to see you again.
Yep.
I feel like we raced into that.
Good to see you. I feel like this is our home away from home. Now we're on Twitter, on X, but YouTube still has our heart. So,
That's a good way of describing it. I'm on Twitter X more, but I'm always a YouTube fan first. So great to always connect, and anytime we can chat, anything to do with real estate is always a good time in my mind. So what do you make of this first and foremost? And I know they have the ability to appeal, and they have indicated that they're going to, but providing what information came out yesterday, what's your thoughts on this?
yeah, I think this is absolutely a landmark decision. This is kind of the ultimate representation of how consumers are growing in terms of sophistication and education, and these laws or these economic structures to protect uninformed consumers but keep the price high is being dismantled, because I really think that the implication is that all buyers and sellers now are negotiate, right? It becomes a free for all where they can negotiate what the commission should be as opposed to a market standard. And the flip side is the market standard protects uneducated consumers who don't know better. They just say 6%, you take it, it's normal. And a lot of people accept it because they need to create an incentive for brokers to take on, smaller homes. You're going to negotiate. There'll be some brokers that want to take 8%, 10%, as opposed to an industry standard. It cuts both ways. And I think what we're seeing on the residential side, 6% is too high. Everybody is pushing back now with median home prices 700, I think 600,000. 6% is too high based on what consumers want to pay.
So, given that they have the ability to appeal, and I know this is an impossible question to definitively answer, but maybe just your opinion on it, given that they've already had a federal jury that found them that they've colluded, what is the appeal process and how likely are they to have success in an appeal?
Yeah, so they would have to find specific allegations in the judicial process, either an application of the existing law or some bias, some piece of information that wasn't allowed in, right, as evidence. It wasn't admissible as evidence, and the judge ruled against it. And they think if this evidence would have gotten in, it absolutely would have had a material impact and changed the outcome of the trial. Because for little things, you're not going to win on appeal just because I didn't get to admit, say like a bank statement. So they have to find something substantive, and it can't just be the finding of liability, right? Just as kind of a clarification. I hate it when people say like they're guilty. I actually saw a YouTube thumbnail. It wasn't a lawyer, but he said NA National Association guilty, $1.8 billion. No, this is civil. There's no guilt or innocence. It is just liability, liable or not. Back to the appeal, they would have to look back at the record and identify some legal process that had a material impact and that they could appeal that specific ruling, testimony, that sort of thing, but not necessarily the facts that the judge or the jury found. So if they say something of like, I punched Chad, you can't appeal a factual finding, if that makes sense. You have to attack the procedure that I admitted hospital bills written on the back of an envelope as being just no precedent for. And they say without those evidence of the envelope bills, there's no way they could have found in favor of me for hospital bills of $12,000, something like that. And again, while they're on appeal, they're supposed to deposit the amount, right? That's supposed to be in court registry. They either can get a bond or they have to pay something that while it's or on appeal, that amount of the damages is in the court registry. So it's not to be taken lightly when somebody says they're going to appeal some of these large monetary damages.
Keller Williams is a privately held company, so don't have the access to see what their financials look like. But I dug into Remax a little bit because they are publicly traded and they have to submit quarterly filings. And Remax has about 144,000 agents, and Keller Williams has 177,000. So it's a stretch and a lot of assumptions that go into it. But I think that there could be some parallel there, as I don't think Keller Williams would be that much different than Remax, considering they're very similar industries and they're very, very similarly run. Remax has about 167 million in total current assets. And cash, I think it was 100 million or so. So I don't know what Keller Williams' portion of this $1.78 billion amount is, but I'm guessing that could be a level that well wipes them out of money. What happens to Keller Williams, and what happens to NAR as this appeal process is presumably going to get dragged out for a while?
Yeah, I mean, these are the types of litigation cases that if the judge doesn't reduce it in his final order, which, we've kind of talked about, he could go up, but he could also go down. And most of these cases, the juries pick sensational numbers, and then the judge usually brings them down to earth. That's historically the pattern for these consumer type cases. However, if their method of calculation, and I've looked at it a little bit because how they calculated was the actual commissions that the agents received, not necessarily dollars that went to Remax, right? So they never actually received this revenue. That was passed mostly through to the agents, but they were finding in favor of the customers who are the homeowners or home sellers, and that's their harm. That came out of their pocket. And so instead of suing all the individual agents, they went after the deep pockets, which makes sense. Back to what happens, this is bet the farm litigation. This is bet the company, because even if it gets reduced to something quote unquote reasonable of 500 million, to your point, it exceeds their current assets. They don't have an ability to pay. Even if it was reduced, they can't put that full amount on cash. And so they have to bet everything on the outcome of this litigation, or they go bankrupt.
What happened? And there's a lot of difference too between a private company like Keller Williams and a trade association like NAR, which I believe is actually the largest trade association in the US by numbers. I'm guessing they've got some deeper pockets, although there's not many companies that can or necessarily want to write a $1 billion check. What happens in the scenario where NAR isn't able to make that obligation?
Yeah, I mean, again, they're a private company. I think it is useful, and I forget one of the defendants, but there was a pair of defendants who settled.
Yeah, it was Remax and a parent company of a few brands.
Yeah, so they paid about 80 million, 82 million. Does that sound right?
That sounds about right.
And so I think they said that was based on their current financials. Let's say they had 85 million in cash. It was literally something like that, where they said, we'll pay everything that we have. And that is a reasonable disgorgement of profits, but that's all we can do. And that resonates with the plaintiffs, because what more are you going to get than somebody's current cash balance? And if the judge kind of takes that into account and levies a penalty that's somewhat consistent with that, but higher, you have to penalize them for going to trial and losing. But he could still take into account their cash and say, disgorge everything that you have. sell some of your assets. Maybe they own some real property, sell it and pay it to these plaintiffs. So I don't know if it was your original question.
Yeah, no, that answers it. Definitely does. But what I was looking to lead into is, how does this change the real estate landscape? Because the judge has the ability to put more than just financial decisions into this. And even if he didn't, the industry has to change. Otherwise, they're just going to be open up to further litigation, and maybe they get sued at a state level or whatever it is. So the industry has no choice at this point to change. I think it's irrevocable change is coming. What does that look like in your mind?
Yeah, so I think there will be changes, and this is kind of a parallel suit with the antitrust and anti-competitive claims. So DOJ has brought this, and they've already, I guess, entered into consent decrees or consent orders about changing the behavior of some of the default, or, it gets very specific, but the government came to a settlement to say you have to reduce or eliminate the option on listings to have a zero commission for the buyer. You have to add that back in or something. You have to very specifically add this on the MLS listings. That is the type of change that I think encourages the consumer to be educated and know that, hey, nothing is standard. There is no market standard anymore. And I think what you're going to see is a ton more negotiation, just like you're hiring a plumber, just like you're hiring, a tree trimming guy. Maybe you're hiring a lawyer, but it's going to, again, create this bifurcated industry of really good people who have compelling sales pitches and maybe get 8%, 9% on a listing. And then you have people that are scraping the bottom to get 1 or 2%, but you can't coast on the 3%. So that's probably what's going to happen is a bifurcation of the real estate agents nationwide.
Another undertone on this proceedings is that the buyer's agent might not be able to be paid from the seller, which is an interesting quirk in agency in my mind, is that a seller enlists a realtor to help them sell their house, and that seller has a fiduciary duty to the seller's agent has a fiduciary duty to the seller, but then a buyer's agent, which has a fiduciary duty to their buyer, gets paid by the seller, which is just the way that agency has worked in brokerage as long as I've known it, and probably predates me quite a bit. But that is an interesting way to do it. And I think critics of that would say that you're starting to get into a camp of a possible conflict. I'm neither judge nor jury. I have no comment on it from a practical standpoint, but I can appreciate that argument. What happens in the scenario if the judge decides that buyer's agents can no longer be paid by the seller?
Yeah, I think it's a parallel in the commercial real estate industry where you have tenant reps. You have a tenant representation who represents the quote buyer in investment sales, owner purchases. But you're going to start to see, I think, people that negotiate their relationship with the buyer because they're getting paid by the buyer, and they're going to negotiate it. Honestly, I think it's probably better given higher price points, given the amount of time, because the other market assumes a 3% of the purchase price as a high carrot, and then it's feast or famine, right? You get a transaction and you get paid well, versus if I was a buyer's agent next year, I'm going to negotiate with you and say, hey, let's pay me $5,000 up front, and I'm going to do all the legwork. And if we buy a house in the first 6 months, then I deduct the $5,000 from the commission. But otherwise, I have to protect myself because I cannot count on a 3% sitting out there. And so it's going to create more work. But in the end, the consumers are going to be better off being able to negotiate how much they pay instead of 3%. So.
Yeah, and you're right. There's a lot of parallel between the residential and the commercial side on that. Even though the industries, there's a lot of differences, the way that agency is treated, it's very similar in that. So I think that there will be a lot of more stories and there'll be a lot more development that transpires from this. But what do you think the immediate effect is? What happens tomorrow?
I mean, tomorrow you're just going to have meetings where all of the local MLSs are going to take a hard look at their fillable forms. Maybe backing up a little bit, each MLS is like a regional governance, right? So in Texas, you just have like North Texas, you have Houston, you've got Austin. Those are all separate MLSs that they can communicate, but you have to subscribe to pay. And while the interfaces are similar, they're not identical. And so each group will have varying levels of compliance. They have their own attorneys. One of my good friends that I played soccer with, he's an attorney for the local MLS, and he's just dealing with tons of issues. This is on his radar, but not necessarily digging into the software. And I think tomorrow they're all going to have meetings with their lawyers and say, what are we doing? Is it compliant? What do we need to change? And those are the problems where the default listing says pay the buyer 3%.
So are those MLSs or local boards or the brokerages, are they at risk of being further sued by state level?
I don't know about state. Certainly the same arguments could be persuasive, but they wouldn't hold precedent because of that federal court. They wouldn't hold precedent on a state court level. But yes, certainly the arguments, and people could file in federal court again and make all the same arguments, and it's very low cost because there's already a trailblazer that won. You just have to follow their path. A lot cheaper, a lot faster.
So these companies and the association at large is certainly not out of the woods, even no matter what the judge decides in this federal case.
Yeah. And I think this one was super important because they represented multiple states. It was a nice region that was a test case. I think that really represents the bread and butter of America, and it wasn't testing a market like New York or San Francisco, for example, where the prices are crazy, the home prices are very high. But this was just your Midwest bread and butter. The prices are probably similar to Texas, Florida, Georgia. It really resonated with that jury. And that's the kind of jury that if somebody is pushing that case in Tennessee, they're going to have the same outcome. They're not presenting this to a New Jersey jury, right?
So I guess the last question that I have on you, and since you and I both become pretty active on Twitter, I think we could easily continue this conversation with anybody that has questions for you. But my last question that I have is, what does and it's a two-part question, but I have a feeling that these two answers might converge. What do you think the real estate brokerage industry looks like in 10 years? And the second part, which I think could tie into it, what would you like the real estate brokerage industry to look like in 10 years?
All right. I'll answer the second one first, because what I would like to see is a very competitive environment where the brokers compete for services and they can set their own price. They can negotiate with their clients. They have their client paying them a very transparent, negotiated, well-documented fee. Eliminate some of the risk of non-transaction. So, like I said, maybe paying $5,000 upfront to go look for some houses, because I think that will really reward brokers who invest in the marketing, the education, and ultimately providing good services. They're going to get paid, and they eliminate some of that risk of showing a person 15 houses and making 10 offers and getting $0 to show for it. That doesn't benefit anybody. They're holding out for this home run. And I think the baseball analogy, go Rangers, right? They're in the World Series.
They might win tonight.
They might win it tonight or the next one. Having a more discerning singles and doubles so that you're getting paid for services performed even if you don't hit a home run. And that's what the 3% was. The 3% was like, there's a home run out there. I just have to stick it out until I get my big 3%. I think a lot of brokers in 10 years from now, they're willing to work and buy the house for 1%, for a single, for a double, for a single, for a double. And they never need to get the 3% home run because it's not reflective of the amount of work that they do on one transaction. The 3% is kind of an average of three failed transactions or something. Second part, what does the industry look like in the future? I think it's going to be very cyclical, regardless of whether the brokers are getting paid on do some work, get paid, do a little more work, get a little bit more paid, as opposed to this 3% just represents a huge home run and they do a lot of work for free. I think you're still going to have boom and bust in realtors because when times are heady and real estate is a cycle, when it's climbing up, the good people with relationships are going to be making money hand over fist, and people will join trying to get a piece of that, even if they're only charging 1%. I don't think that the number of residential agents is going to change from today. It's just going to be still cyclical, but hopefully it'll be less feast or famine and more, are you doing work? You can get paid.
Yeah, well said. That's a really good summary on it. You and I can have this casual conversation, and I'm sure that, and with no stress, we're pretty laid back right now. We could easily have had a drink. I'm guessing there's a lot of boardrooms right now that are filled with a lot of stress for people figuring out what this looks like going forward. Even the point that you made that during the appeal process, they have to put that money into an earnest account where essentially it's escrow. Is that a way of describing it?
Yeah, it's like a court registry.
So that's crazy in itself, that even if it gets reduced to $500 million, that could empty the pocketbooks of two large entities. One, I think Keller Williams is the biggest brokerage by numbers. So that's going to affect 177,000 agents in some capacity. And then NAR, which has, I think, 1,000,005 members across the US. This has implications at like a much larger scale than I think people appreciate.
Absolutely. But I think with the internet, with YouTube, with education, the brokerage community, the residential side, they don't need 3%. That represents an outsized compensation for the amount of work on a single transaction. That's the problem with fixed pricing, so to speak, is that it's just charging too much and it's very hard to break away from that quote unquote industry standard. And this will provide more competition once things are not standard anymore. Sure, there will be agents that still charge 3%, but a lot more consumers are going to be educated and say, well, I want to pay 1%. I'll pay you 1% up front and you get the cash in your hand. There'll be a lot of agents that take that money and then work hard to maybe get an extra 0.5% or another 1% at closing. But the consumer wins, and you don't have this, well, I get paid from somebody else, so don't worry about it. It should make prices come down.
Yeah, like you mentioned, it is very difficult to break with tradition, but in this case, a federal jury and now a judge is going to make that precedent. And the appeal will be interesting at how long this gets dragged out for and whether there's a reversal in that outcome. But that's still sets a pretty powerful precedent going forward that these brokerages, the whole business model needs to change. Otherwise, they're just going to keep dealing with issues like this. So it's going to be very fascinating seeing this unfold.
Well, let me ask you this question. Do you think the average homeowner or home seller is more or less sophisticated than 50 years ago? I don't know how old NAR is, but 40 years ago.
It's interesting. I think that you could say that from a technological standpoint, there's a lot more information available, whereas 30 years ago, there was a paper book, and that book had all the listings in there. Unless you had access to that book, you were excluded from this information. Whereas now there is a lot more information, but it's funny that technology can be a gift and a curse. And it's a gift when you use it to your advantage and you know how you're using it and you can incorporate it for your benefit. It's a curse when it just becomes a crutch and you think that you know everything because that technology is there. So you know that Google's there, but you don't actually use it, or you know that AI is there, but you don't actually use it. Then you might have the false impression that you know what you're talking about, but in reality, you might know less than you actually think. And there's a lot goes into it too. Like it's if you have a 3-bedroom house, well, is that the same as a 3-bedroom house on the other side of town? Probably not. Like there's so much that goes into it. So yeah, technology can be great. And so in a roundabout way, I would say that you could bifurcate people, using that great word. You can do that into 2 camps. There probably are people that really take advantage of technology and they feel that they know as much as a realtor does. And that's not a crazy assumption, because if you've lived in a neighborhood for 30 years and you go to the schools and you go to the churches and you frequent the restaurants and you know all the neighbors, you know more about that neighborhood than most realtors will. That's a fact. So there is that component to it. I'm with you. I can't take a position either way on whether someone is overpaid or underpaid, because there's a lot of nuance and every case is going to be different. I suppose a counter argument that a lot of agents will say is just as you suggested, is that if you make a 3% fee, but it takes you 3 deals because 2 of them failed, you don't get paid for everything that you do. So you have to charge a certain amount for when you perform. What's the right number? At the very least, what I would fully endorse and support is that shouldn't be set. That should be a number that is actually negotiated. So I don't know if that answers your question, but
no, it does. I think what this ruling will allow is for those savvy consumers that have the Redfin app on their phone and they get alerts right when a house pops on the market, they'll be able to negotiate to save money and transact more frequently. For people that aren't comfortable using that tool, they can still pay 3% negotiation. So maybe that will lead to more friction, because people won't do work for free and they want to get paid, but they won't know who to trust to pay for out of pocket.
Yeah, that's a good way of describing it. And personally, that's how I see the industry evolving, is I think it is going to go a lot more towards the advisor or the consultant route, where that's what you are providing. And consultants and advisors generally aren't being paid a percentage of a transaction. They're being paid an hourly rate. So here's the rate, here's my scope of services, here's everything that I'm going to do. And then that transforms the relationship to having to, I need to sell you something, because if I don't, this process for me was a failure. You might be indifferent because if you decided you didn't buy something, it's not going to be a huge draw for you. For me, it's home run or strike out. So I do think that does change. And I think that there will be people that succeed on that. However the model goes forward, this change is an opportunity to retool how you actually do things. And I think that there'll be people that complain about this. There's probably going to be people that think you and I are idiots for even talking about this. We'll probably get some good comments on it, which I always welcome good and bad comments. There will be people that get mad about it, but there will, and maybe not even mad at us, just mad at the situation about court overreach and this was government. I've already seen some conspiracy theory comments out there, but there are people out there that are going to take this and they're going to redefine how they do business, and they're going to come out further ahead. Just like everything. Anytime that there's some kind of change, people do well and people do poorly. And it's just how you adapt to that situation.
Yeah, well, I mean, I think even if you take my pro-capitalist, libertarian, whatever views, I should say these are private entities contracting with private sellers. Who's the government to say that the price setting is legal or not? These are voluntary contracts entered into by consenting adults. Where's the government's going in? And it's that anti-competitive market control. If you control the whole market, it's not good to be anti-competitive.
Well, this will be a fun story to either pick up on Twitter if we get some comments coming in, or maybe we just do another live show on this. I do want to do these more regularly with you, so let's find interesting topics related to real estate or the law or how they could overlap.
Interest rates, no rate hike today. That's super interesting. Super interesting.
Great news. Yeah, I've got some mortgages coming up. I've got one coming up shortly, and I've got another one coming up next year. And the one that's coming up now, I'm not concerned about, but the one coming up next year is giving me some anxiety already. So let's definitely talk about that too.
All right. Looks
Awesome. Okay, well, thanks, Ron. Good seeing you again, and we'll be in touch. Okay, see you, everybody.